Today, I'd like to talk a little bit about legal protection in the EU and the importance of the Court of Justice for the citizens of the EU. So the aim was to create internal market without borders. So to guarantee 4 fundamental freedoms, which are free movement of persons, capital, goods and services. Previously, what are member states today used to be sovereign states with protectionist interests, of course, to protect their own markets. So instead of specialization and doing what their best can do, for example, producing wine in Italy or wool in Ireland, they would produce everything at once. So production of wool in Spain would be overly expensive, while production of wine in Ireland would be also very costly. So internal market and creation of borderless area where goods, persons, services and capital can move freely enabled competition to develop. Competition which will allow member states to specialize and produce the things they're best at, and therefore to build economies of scale. So the aim was to build internal market and make member states to move away from being self-sufficient into becoming interconnected through trade, making previous enemies partners, business partners. The original 6 member states came together and signed the treaties in 1957. The treaties established that there should no longer be custom duties and the 4 fundamental freedoms should be guaranteed. The moment the treaties are signed are actually a dead law. They could be simply put on the shelf. The treaties need interpretation. Treaties are like a skeleton without a flesh. So, in order to make law effective, in order to make it applicable to real-life situations, the law needs to be interpreted. And the task of interpreting EU law was granted or given to the Court of Justice of the European Union, as it is called today. The Court of Justice of the European Union is one of the original institutions of European Union, as it is called today. It is comprised of 2 courts, the Court of Justice proper and the General Court. Article 19 of the Treaty on European Union contains a mission statement of the Court of Justice, or its main task, which says that the Court of Justice must ensure that in interpretation and application of the treaties, the law is observed. What is the law that lies outside of the treaties? This law is generally referred to as general principles of law, which are common to all states, obviously democratic states. For example, the principle of access to justice, the principle of proportionality, the principle of equality, the principle of vested rights, and among other principles. By interpreting the treaties, the Court of Justice looks into the treaty and interprets its provisions for the benefit of all. It is the core task of the Court of Justice to interpret EU law, because if left unchecked in the hands of the courts of the member states, there will not be effectiveness and there will not be uniformity in application of EU law. Different courts from different member states would come up with different definitions, for example, of the term worker or remuneration, or what means different other provisions of the treaty. So it is the core task of the Court of Justice to interpret the treaty and provide us with actual meaning so the law can be effectively applied to everybody's benefit. Majority of disputes in the Court of Justice relate to administration of EU law on the ground or application of EU law on the ground. But also the Court of Justice may review legality of the Union's acts, because not all EU law is legitimate and can be tainted with some sort of illegality. As well, the Court of Justice may take member states to the Court of Justice for disregarding EU law. There is one very important principle enshrined in the treaties. It is called the principle of sincere cooperation, or the principle of good faith, which is also called the principle of fidelity in other sources. It is found in Article 4, Paragraph 3, TEU, and it obliges member states as signatories to the treaty to abide by EU law, to respect all acts emanating not only from the Court of Justice, but also from other institutions, and to abide by EU law in good faith. By the same principles, the member states are precluded from implementing the law which goes in conflict with EU law. So when the Commission considers that the member state has failed to abide by obligations of the fidelity clause or sincere cooperation clause, it may take the member state to the Court of Justice, and then it will be up to the Court of Justice to see whether there was an infringement. Another important action in the Court of Justice is application by applicants, but by those that suffer damages as a result of union action for compensation. But all these actions are direct actions. They begin and they end in front of the Court of Justice, and the Court of Justice is a final arbiter. There is, however, a very important action which is called indirect action. This indirect action, which is called preliminary reference, is enshrined in Article 267 TFEU. It allows the national courts to ask questions to the Court of Justice for interpretation of union law, or indeed on questions on validity of EU law. Article 267 allows member states' courts to ask questions to the Court of Justice, questions on interpretation of EU law or questions on validity of EU law, because it is not for the national courts to actually come up with their own interpretations of the treaty, and it's not for the national courts to invalidate EU law. It is only the task of the Court of Justice to ensure uniformity and effectiveness of the law throughout the member states. This procedure, called preliminary reference procedure, is extremely important. It is called jewel in the crown of the Court of Justice jurisprudence. It is the backbone of EU legal order. Through this procedure, many important principles and doctrines have been developed by the Court of Justice, the doctrines that you and I can benefit directly from. The member states could not put possibly everything in the treaty, so there are a number of gaps, a number of grey areas which needed to be interpreted, and by looking at this treaty, the Court of Justice will interpret the provisions for the benefit of us all. So in essence, preliminary reference means that the national court or the national judge, when applying EU law in the national case, would need some assistance from the Court of Justice, because there is certain lacuna, certain gap in definitions. For example, national judge may not be able to rule on national case when certain definitions are lacking, such as, for example, what is work, what is worker. And therefore, the national judge would ask the question to the Court of Justice. And the Court of Justice, answering this question, will refer the question back to the national court, and equipped with this new interpretation, the national judge would then be able to rule on the case. So through important cases such as Van Gendenloos, Costa NNL and other cases, the Court of Justice has clarified to the member states the true nature of EU law, that it is special, it is original, unlike any other international agreement. It is actually not international, it is supranational. Very important doctrines have been developed through this procedure. For example, the principle of direct effect, when aggrieved individuals, you and I, basically can rely directly on EU law in order to claim rights. So EU citizens can claim rights directly from EU law, be it the treaties, the regulations or directives, which are different types of law that EU can implement.